Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, what's all the fuss about? Brexit and UK competition law. It seems like an eternity that we have been hearing about Brexit and wondering about the implications for competition law in the UK, in the EU, and more broadly. But it seems like finally we have some sense of where things are going. As folks will know, there was an agreement that was reached relatively recently. And we now, I think, have a better understanding. Today we have an expert who is going to explain where things stand and where things may be headed. My co-host today is Matthew Hall. Hi, Matthew.
Hello, John. It's good to be back.
Matthew, what are we doing today?
Well, as you said, John, Brexit, since the vote back in 2016, has been a long, drawn-out process, reached some kind of a conclusion at the end of 2020 when the EU and the UK finally signed a trade and cooperation agreement. You may think that that was the end or is the end of the story, not only in competition law, but in a whole bunch of other areas. Of course, it's not. There's still a lot of things which are unclear and uncertain and will continue to be for some time. Competition law is one of those, and we're going to get a taste of that today from our guest.
Well, who is our guest?
Our guest is Anneli Howard, who is soon to be a QC. She is a barrister at Monkton Chambers, a barrister set in London. She's an expert in numerous areas of law, including competition or antitrust, EU law generally, consumer law and public administrative law, as well as aviation and telecoms, and no doubt probably also a brand new area of what we're beginning to call here EU-UK relations law, which looks at the whole new relationship between the EU and the UK, brand new as of 1st of January 2021. Welcome, Anneli.
Thank you very much for inviting me to speak today. And it's very exciting to be here at what is essentially a new frontier in terms of competition law going forwards for the UK.
As you say, it is a new frontier. Anneli, we've mentioned a bit of the background. We talked about the Trade and Cooperation Agreement, which I think people are generally calling the TCA. But there's a whole lot of other things we need to be thinking about when we're looking at competition law going forward. What are some of those other agreements and regimes that we need to be considering?
Well, I think the initial starting point is that competition law is no longer one set of rules. You know, we basically, for the last 40 years in the UK, we've been part of the European competition network, and there's been a concerted effort to align our national law with EU law to the extent that we were interpreting and applying both our public enforcement and private enforcement in line with the EU rules. And that process has now come to an end. And with the TCA, we're now seeing there's a sort of multiple layers of competition law from various different sources. So for Northern Ireland, under the Northern Ireland Protocol in the withdrawal agreement, well, obviously life will continue as the same. EU competition law will apply. But within the UK, we're now, there is a transition regime for the next probably decade or so, where existing cases and investigations that are in the pipeline that are currently being investigated by the Commission will continue. So European law and follow-on damages will continue to apply in the UK on that basis. But for anything new starting from the 1st of January this year, we will now switch to the UK's own competition law regime. Now, that's fairly established. We've set it out in the Competition Act from 1998. So it's not entirely new, but it does mean that all the references to EU law concepts will no longer apply. We will use our own regime. And we also have this international dimension that's been set up in the TCA. And if you look at the specific provisions in chapters 1 and 2 of that title, it's clear that the concepts remain the same, but we're not using those familiar definitions and concepts of European law. They're going to have their own sort of international general principles that will apply. And apart from that, there is also another layer of complexity through the Withdrawal Act, which cuts and pastes a lot of what we now call EU retained law into our domestic system, and that will also continue to apply up until it's changed by Parliament. So we've got these multiple strands of competition law as we know it, and it remains to be seen how that will apply and be interpreted in future. So that's on the competition law side. We've also got it on the state aid side as well, which is obviously slightly different, but also an important part of competition law.
Yes, as you say, state aid is an important area. And I think it's interesting you make the point there, and I think it comes across pretty clearly that we're looking at a really complex situation, and it's actually more complex than it was pre-Brexit. Good for lawyers, but far from good necessarily for business people. But what about state aid? You mentioned Northern Ireland. It has a special place in the UK, as apart from Great Britain, the Great Britain part of the UK. There was a lot of discussion of subsidies or state aid in the run-up to the final signing of the TCA. At one point, it looked like the TCA would not be signed because of the concerns around state aid. It seems that the UK government wants to have some kind of flexibility, although it's not entirely clear what it would use that for. If it has that flexibility, so does it have the flexibility, and what is the general situation now on the state aid or subsidies, on the subsidies front?
Well, again, it's interesting that as you said, for Northern Ireland, that's a case of, as the French say, plus ça change, plus c'est la même chose. So the EU state aid regime will continue to apply in Northern Ireland, to the extent that that affects any trade between Northern Ireland and the EU. Now, as we know under state aid law, that effect on trade concept is construed very broadly. So it's not just an actual impact on trade, but anything potential or even an indirect effect on trade. So it is conceivable that there will be goods or services from the UK going into Northern Ireland and then onwards to the EU that may still be regulated under the EU state aid doctrine. So that's one level. But then we have multiple other levels as well, both under the WTO regime, which obviously we've been a member of for several years, but under the EU's umbrella. So it's the first time really that UK authorities will need to actively be thinking of whether this is compliant with the WTO and to take measures for it. We've also got provisions under the UK's own FTAs that it's currently rolling over with member states, with third states, but also new FTAs that will be entering into around the world, which will also have a subsidies regime. And we have the TCA provisions. And what's interesting is that, on the government website, if you try and look for state aid regime, you will not find it. Now, that's not just because the UK hasn't published it yet, but it's also because the concept of state aid being a European concept has been removed from the lexicon. It is now very much the definition of subsidy control. And if you look at the TCA provisions, again, it's very familiar, but the EU concepts are not there. So they carry across the general principles of state aid and economic advantage and the exemptions, but it's all set out in slightly different terminology. And the most important change is that there will be no ex-ante control on subsidies. So, under the EU regime, you have to notify state aid and you cannot implement it before it's been notified and cleared. That will not apply anymore under the TCA. Instead, there is an ex post control where a party, which may be a private party or another member state, can challenge it in the courts. But in terms of the actual substance of the law, it looks very broadly familiar. In terms
is the elephant in the room here still the Northern Ireland situation? You mentioned it could be extremely wide. So although the UK government has tried to write out the words state aid, as you say, and replace it with something more UK or at least non-EU specific, is the Northern Ireland situation really going to always be sitting out there in many, many cases where we're looking at subsidies in the UK now?
Well, I think this is the $1 million question to Brexit, because the withdrawal agreement and the TCA have now been concluded, but it's how that's going to be interpreted and applied in future. Now, obviously, under the state aid regime, we're going to have our new independent authority, which will be the CMA. So the first port of call will be, well, how is the CMA going to approach this? Is it going to sort of follow the EU regime, or is it going to have its own independent regime? And then ultimately, how are the courts going to interpret and apply this? Because obviously there's been 40 years worth of EU jurisprudence on state aid, and a lot of the EU retained law. They've now passed a statutory instrument to remove all of that EU jurisprudence from our statute book, so that the UK government is intent on creating its own UK independent regime. But it will always ultimately come down to a question of weight and relevance of, well, will the national court have regard to the position in the EU as a guide to interpretation? And it's hard to crystal ball gaze as to exactly how the courts will approach that task.
It's a classic case of wait and see here, I think. Looking at so let's move on from subsidies to general antitrust or general competition law, please. I think you mentioned that the UK has its own competition law regime in the Competition Act 1998, of course, which has been there for some time, and we've been following in the UK the general principles. If we look at, for example, vertical agreements, very important to businesses, so we're looking at distribution agreements, supply agreements, etc. Do you see any change in that area, which, well, either will be immediate, or lawyers might be arguing, well, look, this type of clause was problematic when we were part of the EU, but no longer needs to be? Is there anything that you see could be changing in that front?
Well, the aim of the Withdrawal Act was to preserve the status quo, so provide legal certainty, provide a stable base for the immediate aftermath of Brexit. And so what that act has done is it has, as I call, cut and pasted the EU block exemption regulations on verticals and the guidance into our statute book for now. So for the moment, those exemptions and that guidance should be the governing criteria for verticals. But it remains to be seen how much that might diverge in future. So firstly, that block exemption can always be overridden by Parliament, and they can form their own economic policy, their own agenda, and change it. But secondly, the courts may shift in their interpretation of what's necessary and proportionate in terms of exemption, or whether, for example, provisions on export bans or provisions on e-commerce and passive selling still maintain the importance that they had under the EU law regime, because those are examples where there was very much an internal market agenda at the EU level. They were wanting to encourage free trade across the whole of the EU market and stop national boundaries. So they took a very hard line on export bans or on passive selling, for example, limits on passive selling. So there is a sort of debate as to whether do those policy agenda, does that still carry across now that we're no longer part of the internal market, or do we pursue perhaps a more US style approach to practices such as retail price maintenance or export bans, where you're really looking at the economic efficiencies that underpin them rather than wider social policy concerns. And again, as on the side of the debate, there are differences as to, which line, whether it's going to be alignment or whether it's going to be divergence. Again, it's hard to predict at this very early stage how the courts will go, but there's obviously fertile ground for lawyers there to make arguments, which will cause some legal uncertainty in the short term until there is a definitive guidance given, probably by the Supreme Court at some point, as to how the court should approach the interpretation of EU law within our domestic legal system.
Yeah, that's an interesting one. So there maybe is a chink of divergence which could already be opening up in that very important area of vertical agreements. What about digital enforcement? The EU has, of course, been doing a lot in this area recently. The UK has also been carrying out its own work and changes coming up to true Brexit at the end of 2020. How do you see that moving forward? Are the EU and the UK going to be in lockstep in terms of going after the big tech companies, or are we going to see some divergence there?
Well, I think regulation of platforms, transfer of data, use of consumers' data is obviously a key priority for regulators on both sides of the channel. As you mentioned, the EU has published their Digital Markets Act, and also they've got their new competition tool to assess digital services. The UK is also coming up with its own regime, though we haven't seen details of it yet. And this is one of the areas where I think the UK wants to forge its own path and apply its own independent policy, particularly because it's very keen on online harms in the digital sphere. So we may expect to see that there are divergences in policy terms between the two. But I think it's encouraging in the TCA that there are very close provisions for cooperation between the EU Commission, the EU 27 national competition authorities, and the UK authorities. And that's not just the CMA, but also the sectoral regulators. So, and there's provision in the TCA itself for them to enter into memorandums of understanding. So, and to cooperate and ensure alignment in areas of mutual interest. So I take that as a positive sign that there will be some degree of coordination between the two. And ultimately, that's necessary because we've got to reduce the regulatory burden for business, having to comply with different sets of regulations when you've got products and services being applied and distributed across 31 different countries. You've got to reduce that regulatory compliance burden, but also minimize the risk of double jeopardy of being, because UK companies will still be subject to investigations by the European Commission or by the 27 NCAs, and they will still face the prospects of fines if they're found to be in breach of competition law. So it's very important that they don't face multiple investigations, both in the UK and in the EU, and the prospect of double fines as a result, or the pit of leniency, where you put leniency into one regime, but it's not recognised in another regime.
As you say, there's a real risk, and I think it's probably inevitable and going to be impossible to avoid in many cases, of parallel investigations. If you mergers is going to happen definitely because of the underlying law, but also these more antitrust type investigations. There seems that there might be coordination, but there inevitably must be additional regulatory burden. I know you've been reading the TCA in great detail, maybe a few times now, since it came out at late December 2020. This is not really competition law, but I think you had a few comments on the new draft UK National Security and Investment Bill, which looks at the foreign direct investment control into the UK, separate from mergers. A big topic on which we had a podcast and sometime during 2020. There's some issues here, I think, between the TCA and that bill.
Yes, well, potentially. Obviously the TCA is in broad terms, but it's scattered into different sectors. So you've got goods and services, and sort of then industry sectors like telecoms or digital services have their own separate provisions. But obviously, mergers is an important part of competition law, and at the moment we've been subject to the EU notification regime. The UK will now be coming out of that regime and will have its own independent merger regime, and will have its own notification thresholds. Now, what the National Infrastructure Bill intends to do is to lower the notification threshold for certain types of industry or certain sectors which are considered to be essential infrastructure for the UK. So the Secretary of State can effectively call in not just acquisitions, but transactions in particular sectors if they are worried about foreign investment, and they can review it and check it. And one of the key areas is telecoms, obviously, with broadband infrastructure, and making sure that that any investment or contribution of assets is not going to undermine public policy or national security concerns. But there are provisions in the TCA, particularly in the investment and capital and establishment sections of the TCA, which prohibit controls on foreign shareholdings. So you might remember 20 years ago, there were all those cases about golden shares and having or the factor tame litigation, which tried to limit the number of foreign shareholders in a particular company. And those provisions, the prohibitions on those sorts of limits are maintained in the TCA. So potentially there may be a conflict between the new call-in powers under the infrastructure bill and those provisions of the TCA.
Okay, that's interesting. It sounds like the National Security and Investment Bill might have to be amended to deal with that problem as soon as the government lawyers identify it. Maybe you already told them already, but there does seem to be a point there. And you say that low thresholds in that National Security Investment Bill. In fact, as I recall, the thresholds are zero. There's no turnover or asset size threshold. It's an incredibly wide provision, incredibly widely drafted bill to become an act. Let's move to litigation. Of course, you're a barrister. You do a lot of litigation in the English and EU courts. What about collective redress claims? The EU has been pushing forward with its own standardizing rules in this area. The UK has also been making some changes. How do you see these things moving along in the two regimes?
Well, I think this is a really interesting area. We've had our own regime for collective opt-in and opt-out class actions in the UK since 2015. But things came to a bit of a halt with the merit ruling before the Competition Appeal Tribunal, which has then gone on appeal ultimately to the Supreme Court, which handed down its ruling late last year. Now, that ruling has made it much easier now for claimants to bring a class action. So we're not going to have a sort of mini trial within a trial. You don't have to produce copious amounts of economic evidence to show, that you've got a high threshold on the merits before you can proceed with your class action. So the Supreme Court has made it very clear that the certification stage is a very low threshold of just showing that you've got a realistic prospects of success, and you don't have to start showing how you're going to assess the individual loss of each claimant or how you're going to distribute it to each claimant. So that's really opening the doors to collective redress in the UK. And as you said, at the same time, the EU proposals are currently going through the trilogue, and they're expected to be adopted and implemented shortly. That is for representative actions within the EU, but they're also allowing funding, which is quite a novel position in some member states. So in Ireland at the moment, you can't have litigation funding. They still regard that as champathy. So there's going to be quite a lot of changes, I think, in the member states to accommodate those changes and to facilitate these sort of representative actions. So it will be interesting to see how the kind of turf war between the UK and the EU will develop, because obviously there's very sophisticated litigators in Germany and Holland and Belgium. There's lots of litigation in France and Spain, and I'm sure that they will want to bring these type of representative actions in those countries, particularly for if they're on a follow-on basis from European Commission decisions. And in the UK, there are a number of cases in the pipeline which are either follow-on or standalone. So I think it's going to be a very busy area for the next 10 years or so.
As you say, there's to some extent turf wars between courts and regimes, even pre the UK leaving. Certainly, particularly between Germany, the Netherlands, and the UK in terms of competition litigation generally. But maybe we could dig a bit deeper and go beyond collective redress into, you mentioned follow-on claims. This has been, if you like, the million-dollar question as well. What is your crystal ball view on what is going to happen to competition litigation generally in the UK, leaving aside the collective redress or class claims? If you're looking at your, if you like, standard follow-on claim, relying on where previously we could, of course, in the UK rely on a commission decision. Is the UK, or particularly the English courts, going to carry on being such an important regime for competition litigation, or is it going to move ever more towards, for example, Germany and the Netherlands? And does it matter? Because maybe the lawyers can follow it there anyway. But
yeah, well, I think,
what is your view?
I mean, there are the doomcasters that say that this is the end, and as of from the 1st of January, there's going to be no sort of follow-on litigation in the UK. That's not the case, because, I mean, if you look at the Withdrawal Act, or if you look at the SI, the Competition Exit Regulations, there's a very clear transitional regime. So any case that was opened by the EU Commission, any investigation that's been formally opened before the 31st of December, is given kind of grandfathered protection. So follow-on actions will be able to continue in respect of Commission decisions for some time to come. Because if you think it takes 5 years for the investigation to conclude, and then you've got the appeals process to the General Court and the Court of Justice, that's 10 years. So there's still going to be a 10-year period in which these follow-on cases will continue. The position for future, and that's even where the decision obviously is going to be handed down after the 1st of January. So what happens for new investigations that are opened after the 1st of January, that you then dig into, or what's the status of those EU Commission decisions in the UK? And there is this sort of watershed in the Withdrawal Act, so that anything before the 31st of December is binding, and that will be your binding finding of liability for the purpose of competition damages. After the 1st of January, it comes down to the individual judge, and they are entitled to place the weight on it, on that decision, and determine how much relevance it's going to truly be. But in reality, that happens a lot anyway in competition damages litigation. We often look at what the FTC is doing or the DOJ is doing, and we pull in those references from those decisions and rely on them before the UK courts. Similarly, we look at what's going on in Asia, we look at what's going on in Australia. So the EU will obviously have the similar status to those jurisdictions, but it's a much closer nexus because we've been partners for 40 years. So I suspect that actually the degree of relevance and the weight that's given to EU decisions will be very high. And I think, a court will have to justify why they are departing from the economic analysis or from the findings of the Commission. And so will only do so really in exceptional circumstances where they feel that something's either gone wrong at the Commission level or they disagree with the economic analysis and prefer the evidence that's being given. I suppose in terms of outcome, it may not be very different. The problem is the uncertainty and the room for lawyers and economists to create inventive arguments to show why decisions should not be followed that will increase costs and create uncertainty. And that's where I suppose, that you've got a balance of serving your client's best interests or, developing creative and ingenious arguments that ultimately may get rejected.
Anneli, thank you. This is really helpful. I want to ask you a question from maybe a slightly different perspective, which is, what does a U.S. law practitioner, what will a U.S. law practitioner see as these changes occur? What will be the things that affect him or her most significantly as we move to the new regime?
I suppose, obviously, if the focus and the priorities are going to be on digital services, there's going to be a lot of US companies that are going to be caught in the fray. And so, where there's an effect either on EU trade or trade within the UK, US companies could face multiple investigations. So that's the first concern. But then also multiple litigation. And at the moment, the way that the damages directive is designed and how it interacts with the jurisdiction regulations, there's a risk of fragmentation. So rather than just fighting on one front in one court, you may end up getting split into litigation in the UK for UK losses, litigation, say, in Holland or Germany. Now, they'll be able to consolidate multiple claims from different countries together, but you're still maybe fighting on two fronts at the same time. And I think, the UK courts and the practitioners in the UK are very confident. So there is also an aspect of, well, why wait for the European Commission investigation to finish? We're not tied in anymore to these duties of cooperation and supremacy. Why not let's just push ahead? So you could be companies could face litigation and evidence and disclosure through the courts ahead of any actual finding by the European Commission.
So it sounds like what may happen is things, if there is a let's say an international cartel problem or an abuse of dominance problem that goes across multiple jurisdictions, what may end up happening is the US may go first, but they may be closely followed by the UK and then EU later. Yes.
Or US companies may get tripped up because obviously there are practices that are perfectly legitimate in the US, such as RPM, such as fidelity rebates and discounts, which are not lawful in the EU and at the moment are not unlawful in the UK, but we'll see how their regime applies. So you may end up not having litigation in the US, but then having to disclose and obviously the UK disclosure regime is much, much more well established and broader than many systems in the EU. So that's a bit of a soft target because if you're forced to get disclosure in the UK, can you then be forced to hand it over to the authorities or to litigation in the other EU states?
Well, let's shift gears a little bit. Anneli, what advice do you have for young lawyers who may want to do what you do?
Are you talking about UK lawyers or US lawyers or EU? Because obviously the TCA, another section of that is recognition of legal services and mutual recognition of qualifications. And that's another quagmire to get into because lawyers are losing their passporting rights to practice across 31 different states. And most of us have protected ourselves. So I, for instance, I've got myself qualified in Ireland, but I've also got myself qualified in Brussels and joined a chambers in Belgium as well, so that I can preserve my practice rights. The services provisions only apply to somebody who's over 6 years PQE. And whilst there are provisions for secondments for trainees, there is not very much for junior lawyers in the TCA itself. So I think students need to be proactive. I mean, US students, if they can do a master's degree in Bruges, for example, or Florence, that will often be recognised as equivalent. So they can actually then use that to get recognition and registration with one of the bars in the EU. So for a US lawyer that wants to have the cross-border practice, that's one way to do it. Similarly, use of secondments or to try and get a specific contract, or one of the gateways in the TCA is to get to be able to do a year contract for a client, which will give you the right to practice, providing you get a visa in a member state. The thresholds actually for getting registered with the bars are relatively easy if you can get your qualifications recognised as equivalent.
And just in terms of career, more generally in terms of career success, any advice for young lawyers about things that are important to do to advance to get to happiness?
Within the law. Yeah, I mean, I think just taking every opportunity that comes and being proactive to look for opportunities. I mean, there are fantastic secondment provisions with the European Commission or with the European Parliament or with the European Court of Justice. Now, they're buried in their websites, but there is a special regime, and some of those are paid secondments. So, anyone who's interested in this area of the law or public international law should be thinking of applying for one of those secondments as they come out of university, because it's an invaluable experience. I mean, I spent 3 years at the Court of Justice in Luxembourg, and it is the kind of it's the equivalent of a Swiss finishing school for European lawyers, because you're in this melting pot of international jurisdictions where you're comparing national legal systems and trying to make it work across 31 states. So that sort of experience, I think, is invaluable and sets you up for life, really. And I think the other thing is mentoring and reaching out for mentors to give you some stepping stones, because it's always easier with hindsight to think, well, that stepping stone, and there you go. But it's hard when you're looking at it from the early days of your profession.
How did you find your early mentors?
I think I was very lucky. I mean, I started out life as a solicitor, and I had some very inspirational partners. And actually, I was approached to go to Luxembourg for 3 years, and I said, what do I do? Because I'd had all my training with the law firm. I felt I owed them a debt, and they said, go, and we'll keep your job open for you. Go and take this amazing opportunity. And I'm eternally grateful for them for doing that. And similarly, when I moved to the bar, again, I had mentors who took me on and brought me onto cases and taught me. So and now, of course, as I'm getting more senior, I'm able to do that in turn, which is great.
All right. Well, shifting gears a little bit. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
So I never dreamt of being a lawyer. I'm one of 6 children, and my family are all medics, but I hated blood. And what I really wanted to be was to be an Olympic gymnast. And I probably spent more time between the age of 4 and 24, either on my hands or up in the air, than I did on my feet. And in some ways, that's taught me a lot of life skills of juggling and balancing different demands.
So, and when you were a gymnast, what was your specialty?
I love tumbling. I walked into the gym when I was about 6, and I saw the kids doing their somersaults, and I said, I want to do that.
So like floor exercise?
Yeah, floor. And
how did you choose your music for your floor exercise?
I wasn't a natural dancer. I have to admit that. I was never going to be one of the ballet. In fact, I think my mother tried to put me into ballet, and I was the kid climbing the wall bars. So I always went for, I love the tumbling. So I was always going for a much more punchier music that sort of hid my lack of balletic elegance, but enabled me to release the firepower when it came to the tumbles.
And do you remember any of the songs that you tumbled to?
My favorite gym routine, I think, when I was about 15, and I actually did it to Def Leppard. And I had this opening shot where I opened my tumble right at the beginning of the routine to the Def Leppard. It raised a few eyebrows, I think, back then in the mid-'80s, but I loved it.
I do not recall any Olympic gymnast ever tumbling to death metal previously.
That's why I didn't make it.
All right. Well, let's go to our final segment, The Curious Hat.
And now it's time for The Curious Hat.
So when we were all together, typically I have a hat, and in the hat is a series of questions, and the guest pulls out a question from the hat, and we ask that question. Since we're not all together today, I have a list of the questions that are numbered from 1 to 25. I will ask you to choose a number, and I will read the question that corresponds with that number.
Okay. I'll go with 7. Lucky number 7.
All right. Number 7. What was your very first job?
My very first job was probably working for my father when I was about 12. I was a very belligerent student, and I think I got called in for winding my French teacher up. And my father at the time was a doctor, but he also ran a journal for a European respiratory journal. And he was so fed up with my attitude that he set me to work over the summer doing the data processing for his French journal. I had to put all the accents in the right place. It was very good penance for my lack of respect for my French teacher.
All right. And what was your very first hobby?
My very first hobby was probably tree climbing. I grew up with 4 brothers, and they always said, "You can't do this, you're a girl." So I had to prove them wrong.
Well, it sounds like you kind of have made a career out of doing that. So, Anneli, thank you for joining us, and we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.